Right. Can you strike off a company with debts and that's insolvent? And the answer is you can. Don't let anybody tell you different. You don't have to come and see somebody like myself to put a company into liquidation, for example, when it ceased trading, in order to dissolve a company. You can close a company down that's insolvent. It is possible, but there are restrictions, and those restrictions are severe. And what I mean by severe is if you get it wrong, it can result in a criminal offence and you can be fined because those restrictions are strict. Now, the procedure that I'm talking about is voluntary strike-off under Section 1003 of the Companies Act 2006. Now, if you want to strike off a company using that procedure, it's a relatively cheap procedure. You can just find your way over to Companies House and there you fill in the form. I think it's £33 online. The form's known as the DSO1 form, and the form will caution you about the consequences of getting it wrong. Now, the two key areas where you can get it wrong. Okay, one is the question of effectively insolvency type procedures associated with the company. That's one, and the other is the trading of the company or change of name of the company in the last 3 months. If the company has done any trading activities whatsoever in the last 3 months other than simply paying the pre-existing creditors in some way, shape or form, such that it is not part and parcel of essentially the striking off and the dissolution of the company, then that will constitute trading activity which is prohibited for the use of the DSO1 until a 3-month period has transpired. Now, the other aspect of it is if the company is subject to what's known as a Part 26A restructuring under the Companies Act, a company voluntary arrangement is being wound up by the courts or going into voluntary liquidation. Any of those types of issues and the company with debts, you cannot use a strike-off procedure in those circumstances, and the penalty for getting it wrong is severe. It's a criminal offence. It's not trivial. You can be fined, and it does happen. It's not something that's a law that's never enforced. If you're not convinced about that, you can go and actually have a look at this at Companies House yourself and look at the criminal offences and fines statistics. They're there on public record for everybody to see. That doesn't mean that everybody that falls foul of these provisions automatically gets a criminal record, but what it does mean is that it is a severe criminal, and it's a criminal offence if you get it wrong. However, notwithstanding that, if you comply with the procedure, you must send a copy of the DSO1 to any creditor, any member of the company, any creditor of the company, any employee of the company, any director of the company that's not seen a copy of it, for example. You have to ensure that all the relevant persons see a copy of the DSO1 within 7 days of it being issued to Companies House. And the reason being is that gives those people an opportunity to object. And Companies House will consider that objection. Now, if you think, we'll just simply send it off and we won't bother sending it off to all these people who can object because we don't like the fact that they might object, that is where there could be a problem, because, again, that can be a criminal offence, or would be a criminal offence if you failed to provide a copy to all those relevant parties who would otherwise have the right to object. Now, there are people like HMRC, bounce back loan lenders and so on who routinely object, and indeed obviously creditors who've already engaged in litigation and legal proceedings who would automatically object to try and stop the process, and a Companies House would be sympathetic, and they generally would stop the process for at least 6 months, sometimes longer. It can roll on in a zombified state for a long period of time, and the directors of the company still have an absolute duty to file accounts and to file confirmation statement and to file a corporation tax return, regardless of the fact that there may not have been any trading or otherwise, and it will be a criminal offence if you fail to file account and if you fail to file a confirmation statement. Obviously, lots of people can't be bothered with all this, and they just want to be rid of the problem, rid of the risk, rid of the accountancy fees, and sort the company out, properly orderly winding up. They come and see somebody like me, licensed insolvency practitioner, liquidator, and we will then liquidate the company. It cannot be objected to by creditors, and it can be done and dusted. Questions, queries, concerns, give us a shout. We know insolvency inside out.